Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. I'm Matt Starosiak in the studio just outside of Atlanta with my colleague and friend, Robert Capovilla. Hello, Robert.
Hey, Matt. How's it going?
I'm doing great. Nice to see you today. Nice fall day outside.
Yeah, it's a beautiful time of year.
Yeah, perfect. So, and then we have a call-in guest who really isn't a guest. He's a member of the law firm of Capovilla and Williams, Brad Simon. Hey, Brad, how are you?
Doing well yourself, Matt.
Good. Nice to see you. Nice to hear you, I guess. You're down in Texas today, I take it?
I am. I'm actually home, which is nice.
Yeah, very nice. I know you've been out on the road quite a bit, doing good work, so it's nice to have you with us. We've got a great show on tap. We're going to talk about a case that came out. Is it a recent case? A recent case?
It's a recent case.
Okay, good. Well, perfect. Our listeners will love it.
And so let's start with this, Brad. What are the facts of the Mendoza case?
Yeah, of course. So Sergeant Mendoza, he was stationed at Camp Casey out in Korea. And him and a couple friends, they went out drinking along with the alleged victim, J.W. And they all went out drinking, having a good time. They came back to the barracks, and J.W. drank to the extent that she blacked out. And in the record that's in the CAF opinion, it says that she blacked out and she didn't remember anything until she was awoken to Sergeant Mendoza knocking on her door, asking if she returning her shoes or something of that nature. She then goes back to sleep and is woken up again to Sergeant Mendoza knocking on the door, asking if she was okay. And she said, yeah, I'm fine, or something of that nature. She went to the bathroom, and then this is where the case takes a turn. She went to the bathroom and noticed, in her own words, something was wrong because she wasn't wearing her underwear, and her tampon was pushed all the way inside of her where she couldn't reach her string. She stated she's never put a tampon in that far before, and she wouldn't have had sex with a tampon in. She immediately went to CQ. Supposedly she was crying and upset. They took her to Sharp and got a state's exam done. And then this is where Sergeant Mendoza, without knowing all the facts, it appears might have hurt himself a good amount. He was questioned by his NCO and a fellow soldier, and he told them that J.W. fell asleep in his bed. Nothing happened, and she later on locked herself in the bathroom. However, when he was questioned by CID, he did state that he had sex with J.W. He knew that she was extremely intoxicated and incapable of consenting, and that he was in control the whole time. So that's kind of the background of the case, and that's what led to the court-martial.
Okay, so now that we have the facts, what was the reason the case went on appeal to CAF, and what were some of the issues they were looking at?
Of course. So it starts with the first level, which is in the Army called ACCA, Army Court of Criminal Appeals. And there, Sergeant Mendoza, through his counsel, raised two issues. He raised the factual insufficiency and legal insufficiency. The factual, based off of what ACCA wrote, and CAF kind of talked about a little bit, was that he said there was no evidence, no direct evidence, only circumstantial, that she did not consent. But the big argument, the one that got some teeth, was the legal insufficiency of the charging scheme. And that's what is Article 120, Bravo 2 Alpha versus Bravo 3 Alpha. And that's without consent versus incapable of consenting. Now, ACCA upheld the conviction, but CAF actually remanded it back to ACCA. And we'll talk a lot about that, I'm sure, about the difference in what the legal, the charging scheme and the ramifications that come from this.
Okay, so we have the factual insufficiency, which, back in the day, quite frankly, before the change in the law, when I think it was U.S. v. Thomas said you need at least one thing to corroborate a confession, that might have had some more steam back before that was, U.S. v. Thomas was overturned by case law. But you're saying from a legal sufficiency, that's what CAF really focused the majority of its efforts on. And Brad, what did CAF conclude and why?
So they really reviewed that the government charged without consent. So that's Article 120, Bravo 2 Alpha, without consent. But they argued at trial and entered so much evidence they being the trial counsel, of JW being incapable of consent due to her high level of intoxication. They put on testimony about how she was so intoxicated, her BAC. And what CAF really focused on, and there's a quote in here that I want to read in particular, and it comes from U.S. v. Riggins. It says, what the government cannot do is charge one offense under one factual theory and then argue a different offense and a different factual theory at trial. Doing so robs the defendant of his constitutional right to know what offense under what legal theory he'll be tried and convicted. And what that means is if you charge the accused, and in this case Sergeant Mendoza, of engaging in a sexual act without the consent of the other person, but then argue that she was incapable of consenting, that's an issue. Because without consent means the person could or did not consent, but they had the ability to. Incapable of consenting means they couldn't have even consented if they wanted to because they were so drunk. And if you're arguing one theory but charging another, it puts the defense and the defendant on improper notice and is unable to put on a great defense and to be able to attack the case properly.
And let's talk about sort of the history behind this, right? So I don't remember exactly when the definition that is currently used in the judge's instructions of consent came out. But I do remember practicing cases before the most recent definition came out that did not include only a competent person can consent, right? So traditionally speaking, when I was both a prosecutor and then a trial defense attorney, and then my first 2 years out as a civilian lawyer, the government would, if they believed that she could not consent because of an intoxicant or because of sleeping or because of a drug, they would have to rest on the theory and prove beyond a reasonable doubt that because of those issues, she was incapable of consenting. And a lot of times with alcohol, it was incapacitation, right? And we would have typically back in the day, you know, the government would have to prove beyond a reasonable doubt that she was incapacitated. They would do that through presenting evidence of how much alcohol she drank. Sometimes there'd be a BAC, sometimes there wouldn't be. They would put on, you know, forensic psychologists or even more frequently toxicologists to talk about the alcohol's impact on her ability to consent. And then the defense would argue basically the opposite, right? We would argue things like, well, the alcohol use would not have, you know, prevented her from consenting. We would typically have our own toxicologist or forensic psychiatrist or psychologist to get up there and talk about the impacts of alcohol, to talk about the impacts of blackout versus pass out, right? That was a very big point of contention with these earlier cases. And then all of a sudden, the definition came out that said only, as the generic definition of consent, it said only a competent person could consent. And it says other things, obviously. And then what I saw happen slowly over the years was we would have a case where they would charge, like in Mendoza, that she was capable of consenting but chose not to. And in those cases, the government would do exactly what happened in Mendoza. They would call witness after witness to talk about the alcohol level. They would put on pseudo arguments of incapacitation. They would call their own experts to talk about incapacitation or even the impact. More usually it'd be the impact of alcohol on the body, right? And they would make this argument to the panel that even though they charged it that she could have consented but didn't, that under the definition of competency that's laid out, and there is no definition of competency, let me rephrase, under the definition of consent that talked about competency, that she wasn't competent to consent. And the problem was the courts never really gave a definition of competency. They never really went any further than saying, well, the instruction says that she's got to be competent to consent, and we're going to allow the government to put on all this evidence that she wasn't competent to consent. And I objected to that. I don't know how many times, Brad, over the years. Every single time I ever saw it, I objected, right? Every single time I ever saw it, I objected. And I was told, sorry, Mr. Capovilla, it's in the instruction. You need to be prepared to defend that she wasn't competent to consent. Is that in line with, you know, your understanding of the history of how we got to this point?
It's spot on, Rob.
And so CAF says, okay, from now on, government, you can't charge that she could have consented, but did not consent, and then argue that, in fact, she was incompetent and therefore could not consent. So take it from there, Brad. Is that what they concluded? Go ahead.
To some extent, yes, but not fully. So what they did actually, and it's where it gets weird, is they sent the case back to that lower court we were talking about, ACCA, the Army Court of Criminal Appeals, to flush out their explanation as to why the conviction was legally sufficient. And they basically say, hey, ACCA, we want you to explain this, and we understand you didn't have the understanding that we have now put forth. And what they put forth was that government, you could, in a sense, charge an alternative, and we'll talk about that, what that means, and what we think we're going to see going forward. But what you can't do is charge under without consent and then argue incapable of consenting, because what makes it incapable of consenting actually a little bit harder, in a sense, is that the government must prove not only the victim was incapable of consenting, but also that the victim's condition, the alleged victim's condition, was known or reasonably should have been known by the accused, and that the accused had that knowledge, right? So what that means is, what Cass held was, if the government's able to charge under without consent, but argue incapable of consenting, they're making it easier because they don't have to prove the accused mens rea beyond a reasonable doubt. So basically, Cass said, hey, these aren't the same things. We have to review the text of the language as it is, meaning take it as what is written. If it was the same thing, there wouldn't be two charges for it. And so they basically said, ACCA, explain how you got to legal sufficiency, because we think they charged it improperly, and the defendant, Sergeant Mendoza, didn't have proper notice. And they're sending it back to them, and there's a chance this case could get fully overturned based off of the new reading of the law that Mendoza put out. It came out October 7th, and it's going to have great ramifications going forward, because like you said, Rob, this has been an issue that's been happening for a long time. And they charge and they argue something else.
Yeah, and it's an issue that doesn't just impact the verdict. It impacts the trial from start to finish and what the rights of the accused actually are. Because, Brad, I remember numerous occasions where I would want to get an expert, a forensic psychologist, to help me argue, to help me prepare for cases that involve alcohol. And the government would routinely deny our request for experts, and it would have to go to the judge. And then they would stand up in front of the judge and say, well, Your Honor, we didn't charge incapacitation here. We didn't charge it. So we fail to see why Mr. Capovilla or the defense needs an expert to educate them on the impacts of alcohol when we didn't charge it that way. And then, lo and behold, we get to trial, and what do you think they do, Brad? It's all about alcohol. And so most of the time we were successful in getting our experts, because obviously we have a right to put on a defense that exists separate from how the government charges the case, right? And I would argue, well, Your Honor, we need to make sure we're prepared for this idea that she could have been blacked out, consented, and doesn't remember. And so we would get the experts a lot. But there was one occasion where we did not get the expert because the judge said, well, they haven't charged it as incapacitation, and I'm not going to grant the expert. And that trial got continued midway through because, lo and behold, the opening statement was, what do you think, Brad? We have competency. Right.
Yep.
Right. And so the way that the cases were working, it wasn't just impacting verdicts potentially, it was also impacting our ability to properly prepare, which is why I think CAF, in part, highlighted the notice issue. So, Brad, as succinctly as you can, let's get a concrete holding here on the podcast. What is the holding? And then we'll talk a little bit about best practices moving forward.
The holding is that the conviction at this point in time is remanded back to ACCA to explain, was there legal sufficiency? Meaning, did the government charge this right? And was there evidence to support it? And it's going to be something we're going to have to watch, because if ACCA overturns this, it's going to have ripple effects going forward.
So, understanding the law, understanding the holding, let's assume for a second that CAF essentially comes down to the conclusion that you can't charge it one way and prosecute it another. What are 2 or 3 learning points? What are 2 or 3 recommendations you have for defense attorneys that are listening to this on how to proceed moving forward in these kinds of cases?
Absolutely. So the first and foremost, I think it starts at the start of the trial. And when I say start, I mean when they prefer charges. There's pros and cons of going to Article 32s, but there may be a new pro of going to Article 32 and having the foe say, no, there's no evidence of incapable of consent, or there is evidence of incapable and you shouldn't charge without consent, and force them into a charging scheme. Now, there are also may be reasons why you don't want to do that or don't want to give an opportunity. The other best practice going forward is filing a bill of particulars. Make them explain. And the way you can do that also is filing a motion to them to basically their charging scheme. And there's some case law out there on that, US v. Sandoval and US v. McDonald, Vital as well, that basically it forces the government to explain their charging scheme. And I think one of the last best practices as well is at the end of the trial, before they go to closing. It won't always be successful, but you can stand up and ask the court mandate the government pick their theory before closing arguments and then file a 917 on the other one. Because what they can't do is stand up and say without consent and argue alcohol during their closing, because that's not the same law. That's what Mendoza CAF really sent back to ACCA, saying you can't do both of these. You can't charge one and argue the other. Now, the biggest fear out of all this, in my opinion, Rob, is going to be charging the alternative. They're going to charge both and just leave it up to the members to decide and say, hey, figure out which one you think it is, member.
And that's
what that does.
Oh, go ahead,
Yeah,
Brad.
sorry.
No, go ahead.
That, to me, is scary. If they're able to charge an alternative, because then it gives the government full access to argue anything and everything they want. And now they wipe their hands of it. They move it up to you. Now, quick practitioner point. I think you get to stand up there as defense counsel and say, look, members, the government doesn't even know what happened here. They're telling you she was capable of consenting. It didn't happen. And then they're telling you she couldn't even consent. They have completely different wild theories. And you've heard that through the trial. Members, if they don't know what's going on, you don't know what's going on. And that's reasonable doubt. Now, it's not the most persuasive, but it gives you something at least to kind of counter that alternative charging.
So let me ask you this, Brad. When you said, hey, you may want to consider taking some of this to the at the Article 32, your point there is if they do charge in the alternative and there really is no evidence that she was incapable, you make that specific argument at the 32 to get the recommendation to have that charge removed, so then you're able to focus in on just one of the specs moving forward.
Exactly. Yeah. And you hope that the preliminary hearing officer, the foe, does see that, and that could be your argument. You might not put on any other evidence other than she was or he was capable of consenting, and therefore that charge goes away or that spec goes away. And now you can narrow the focus, it narrows the government's argument, and it narrows the scope of the evidence that'll be coming out going forward.
So here's a question that I don't think you're going to know the answer to, but I'm interested to hear your thoughts. Let's assume for a second that it is upheld that there was legal insufficiency here, and the case does get overturned, and CAF comes out and says you can't charge it one way and argue it another. What's that going to do for all of our service members who are in jail right now because the government charged it one way, argued it another way, and the defense lawyer was likely caught off guard or ill-prepared to handle the dynamics of that situation?
So from my understanding of it, it won't have a ramification on them. They can make an appeal and they can cite the new law, but that wasn't law at the time of their case and their conviction.
That is something that I find to be difficult to grasp, because I have long been public on this podcast and in the courtroom that what the government was doing was unconstitutional. And my heart, and I mean this, my heart breaks for these service members who are sitting in jail right now because the government argued that she was capable of consenting but chose not to, and then they just utterly littered the panel with alcohol evidence. And these young folks, primarily young folks, but our service members are going down in trials for cases their defense attorneys really weren't even on notice to defend. I think that quite frankly hurts my heart.
It does, and it's awful because the defense is then forced to try and counter alcohol. And let's just assume it's alcohol, the BAC level of what it was when they went to get a safe exam done, or the testimony of that she may or he may have been fallen over or sick. That's irrelevant, because if they charge without consent, meaning they could consent. So no matter how much alcohol they had, The government noticed it as without consent, saying they could have done it. And yet the defense now here is having to chase a red herring because the government is slandering and putting this damaging prejudicial evidence before the panel, even though it should have no relevance as to the charged offense. And it's awful. But I don't see them being able to cite this new law for something that may have happened 3 years ago if this does become new law.
Yeah, no, I agree. I think your scenario is exactly what's going to happen. And certainly, if you're a defense attorney that is representing service members and you're listening to this, we're going to be putting together some materials in-house that are going to help all of us do a better job when alcohol is involved, and how to handle kind of the alternative that we think is going to be happening, and also how to best prepare yourselves for cases if Mendoza doesn't turn out the way that we think it is. So don't hesitate, if you're a defense attorney listening to this, to contact us, and we can start helping you get some of the stuff that you need, because our mission at Capovilla Williams is very clear. We're here to help our service members. And quite frankly, I've thought for a very long time this law was wrong, and I'm glad that it's being addressed, and I'm glad that we have guys like Brad Simon out there doing this at a high level, and it's something we're passionate about. So, Matt, I'm going to turn it back over to you. Brad, outstanding job, and please don't hesitate to, if you're listening to this, like I said, and you're a defense attorney representing service members, to reach out to us. We're going to help you with what you need.
Hey, Brad, just a couple questions. Fascinating discussion, by the way, and it's really impressive to see how well you know this material. But in terms of the ACCA, what is it CAF? What do they review? Is it a written opinion that they review? And then when you had mentioned a couple times they sent it back down for an explanation, how does that explanation happen? Is that another written opinion? Is that something more informal? Is it a new proceeding? Can you talk a little bit about the logistics of that?
Yeah, of course. So how the whole review works is, heaven forbid a service member is found guilty, they get to appeal it. And that means they get to raise issues that they think happened at trial that shouldn't have happened. And their appellate counsel will write a brief, a written memorandum to the appropriate court. So if it's Air Force, it's AFCA. If it's Army, it's ACCA. Navy Marines, it's NIMCA, NMCCA. And they write a brief, and then the government responds to it. And sometimes they get to have oral argument, but it may just be written. And that court then reviews and says, okay, yep, we agree there was some error here, or no, there was no error. And each one has different standards, beyond a reasonable doubt, harmless error. I won't bog down into that. And then from there, depending on what that court does, if they grant relief to the service member, it can go back to trial, or it could be reheard, or the case could be thrown out altogether. If they don't grant relief, the service member then can appeal to what's called CAF, the Court of Appeal for the Armed Forces. It's essentially the Supreme Court of the military. And they get to decide whether they hear the case or not. And from there, they then decide if there was, error or prejudice in the case. And in this one, when they send it back, or what they call remand, they basically will send the entire record back to the Army Court of Criminal Appeals, where they'll publish another opinion. They'll review the evidence again. They'll review the opinion that just came out from AFCA, or from CAF, I apologize. And then we'll write a new opinion and decide whether Sergeant Mendoza appeal does have merit and the case could get overturned, or they'll decide that it didn't. And so that's kind of how the process works there.
Okay. So ACCA will produce another opinion, and then things will go where they go from there.
Now, I will. CAF is careful too in what they do, and understandably so. I mean, even in this case, the Sergeant Mendoza case, they even write in their opinion, nothing in this, opinion bars the government from offering evidence of an alleged victim's intoxication to prove the absence of consent. Conversely, nothing bars the defense from offering the same evidence to show reasonable doubt. So basically, they're saying, hey, we're not telling the government how to do their case or not to do their case, and we're not saying you can't offer this. They're very careful as well. But I do agree with Rob that this is the first time they're really taking a deep dive at a very serious and significant issue that has been raised countless times. And it seems like we're finally getting some teeth to hopefully correct this.
Well, that's a great kind of parting shot, and we'll obviously be keeping a close eye on this case and others. And we're certainly going to have you back, Brad, when this comes to a final resolution, so you can talk about that and the ins and outs of it. But again, just phenomenal knowledge. Just Rob and I were kind of writing notes back and forth to each other as you were talking about how sharp you are on this stuff. So we're glad to have you on the Capovilla Williams team. Thanks for joining the Military Justice Today podcast, and I think Robert's got one more thing he wants to say.
Now, before we close out, these notes between Matt and I, Brad, are not discoverable. However, I am looking at a note from Matt that says right now, Penn State is lucky they're not playing Michigan this year because we beat them by 3 touchdowns, cheating or no cheating. So there you go.
I'll let Matt live in fantasy land.
There you go. There you go. All right. Well, Brad, great talking with you today. Thanks again for being on the podcast. We will talk to you soon. And to our listeners, thank you very much for joining. Take care. Be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.